If you like to get geeky, you're going to love this episode because we are going to break down in extreme detail a particular argument that we keep seeing by the anti-gun community in attempting to ban AR-15s, AK-47s, and magazines that hold more than 10 rounds. You're going to see how this is disingenuous and how the anti-gunners are trying to dupe courts into getting this wrong. But they can't because the Four Boxes Diner is here to point it out. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out. All right, folks. So we're going to get geeky here. Very geeky. And I'm proud to say that I think I am the first and perhaps the only person to figure it out about what I'm going to say. Although I've been spreading the gospel, spreading the word about this, so hopefully a lot more people have picked up on this now. Because I've been telling everyone that I know and encouraging people to follow this and understand this. And I wrote a major article about this, which I will link to down below for those of you who really want to get excitedly geeky. In the Harvard Journal of Law and Public Policy, you will see the extreme detail of all the arguments. And I think it's been cited in courts recently as well, though I'm not sure of that, but I suspect it has been. Okay, so here's the story. As you know, if you want to ban a gun, if you want to ban an arm and you're the government, you cannot do it unless you, the government, proves historically that the gun or the weapon, the arm you're trying to prove is dangerous and unusual. For all intents and purposes, here in modern day America, any of the guns that the anti-gunners are trying to ban simply cannot be banned as a matter of Second Amendment jurisprudence because everything they're trying to ban is in common use by Americans for lawful purposes. That's AR-15s, that's AK-47s, that's magazines that hold more than 10 rounds, that's going to be suppressors, things like this, okay? Now, there's a game that gets played by the anti-gunners to get around this and all sorts of laws they don't like. It's a single sentence that falls within the middle of the very long opinion by the U.S. Supreme Court in NYSRPA versus Bruen. And this is a sentence that's been misconstrued not just by lawyers, and not just by lawyers, but also by many courts, especially those courts in terrible jurisdictions that are all blue. They got picked and put on the federal bench, likely by their two blue state Democratic senators, and in many instances by blue state Democratic presidents. So they're all terrible on guns, just about. And they take advantage of anything they can, and they play games with what I'm about to teach. Specifically, there's a sentence in Bruen that reads as follows. And you'll see how it's misconstrued, I think in many instances on purpose, but we'll see. Here's what Bruen says about the way you analyze and apply historical analog laws. And just as a reminder, you know how it works. When you're dealing with a Second Amendment question, there's an interpretive method, an approach of how you go about interpreting the Second Amendment and applying it. You start with the text of the Second Amendment, which is the right of the people to keep and bear arms shall not be infringed. As defined, those terms are all been defined by the U.S. Supreme Court in Heller. You apply those definitions, and if the text is satisfied or the text implicates the modern-day gun control law, the presumption is that modern-day gun control law is unconstitutional. The burden shifts to the government, and it's up to the government to come forth with historical evidence, i.e. historical analog laws, going back to the creation of the Second Amendment in 1791, to show that it's a long-standing tradition to have the kind of laws that are on the books today, going all the way back to the founding. That's the way it's supposed to work. Now, you also know that if you're dealing with an arms ban case, such as a ban on an AR-15, a ban on handguns, a ban on butterfly knives, a ban on magazines, all of these are arms, you know that you do not have to go through and do that historical analog work again because the Supreme Court already did the text first and historical analog spade work when they decided the Heller case and came up with the legal test that says then unless the government can show a particular arm is dangerous and unusual, it cannot be banned. And because all these weapons are in common use by Americans for lawful purposes, they cannot be banned because they cannot be unusual. And thus, since they're not unusual, they cannot be dangerous and unusual, the government loses. Because that is such an easy test for us to satisfy with all the issues being fought out in the court literally today, the anti-gunners have looked around this. And the way they get around this basic black letter law of the in common use test is by pretending it's not the law. And one of the ways they pretend it's not the law is applied to AR-15s and AK-47s and magazines and suppressors, is they quote this sentence in Bruen out of context. And in many instances, they don't quote the whole sentence, they just quote half the sentence. To me, not acceptable. Here is what the sentence says, and I'll put it on the screen as well. The sentence talks about how you apply historical analog laws in new types of cases that haven't yet been dealt with. Okay, dealing with new situations. Here's what it says, quote, while the historical analogies here, i.e. in Bruen, while the historical analogies here and in Heller, that's key, you'll see why, and in Heller are relatively simple to draw, other cases, meaning other cases besides Bruen and Heller, implicated unprecedented societal concerns or dramatic technological changes may require a more nuanced approach, period, close quote. So what happens is in the real world is the anti-gun lawyers in many instances grab this language and tell the courts that, hey, if we're dealing with an unprecedented societal concern, mass shootings, or we're dealing with dramatic technological changes, semi-automatic rifles like AR-15s, AK-47s, or magazines that hold more than 10 rounds, then we can simply throw out all the Second Amendment jurisprudence of the Supreme Court and do whatever you want and just claim they're too dangerous because you're dealing with the unprecedented societal concern of mass shootings and you're dealing with dramatic technological changes of semi-automatic rifles and magazines that hold more than 10 rounds. That's what they do. That's the sleight of hands, and courts keep accepting this and embracing it, the lower inferior courts. But should they? And the answer is 100% no. 100% no. In my entire article in the Harvard Journal of Law and Public Policy, I lay out below if you're a lawyer or you're litigating this case, if you're a law clerk or judge, and you want to get the definitive answer on this, at the highest level of legal geekdom and highest level of Supreme Court litigation style and practice, check out my detailed scholarly article. That way you can use it, cite it, and embrace it and rely upon it in all of your work at the highest levels of the society. But for the rest of us, you don't have to get that geeky. You can just hit the highlights of the article to show how absurd the anti-gun argument is trying to use this sentence for where they're trying to get. To begin with, just textually, just look at the text. I'm going to put it back on the screen right here, right now. Okay, look at the text. The first is, as you know, that what is Heller? Heller did the text first, historical and analog work second, gave rise to the in common use test. So what's happening here is they're trying to say that all they need to show is that unprecedented societal concerns in mass shootings and dramatic technological changes in semi-automatic firearms give rise to, we can get around and ignore Heller and Bruen. It's not true. Just look at the text, because the text itself shows that's a lie. Because it starts off by saying, while the historical analogies here and in Heller are relatively simple to draw, other cases, i.e. other cases other than Heller, that happen to implicate unprecedented societal concerns or dramatic technological changes may require a more nuanced approach to the analogs. But they're specifically carving out the Heller decision from these other cases that may implicate these societal concerns or technological changes. So they're not changing the law of Heller, which is the dangerous and unusual / common use test. So you can't use the sentence to get around Heller because it specifically says you can't do it because they're excluding Heller from the language involving this unprecedented stuff, unprecedented concerns and unprecedented dramatic technical changes. So at the textual level, their argument cannot work, number one. Number two, it makes no sense just implicitly. If you think about the arms ban case that we see in Heller as opposed to these quote-unquote other cases, the in common use test already encompasses all modern societal concerns, right? And all dramatic technological changes, because the Supreme Court always says we have a Second Amendment right to modern firearms technology. We're not wedded to the firearms technology that existed at the time of our founding in 1791. We get modern firearms technology. That's what Heller said. That's what the whole Bill of Rights is about. That's why we have First Amendment rights to modern day computers and phones and televisions and the like that didn't exist in 1791. But then if you go on, of course, the whole idea of having modern firearms means you have semi-automatic weapons. That's what a modern firearm is, because you go back to 1994, the Staples case, the U.S. versus Staples case, they're talking about semi-automatic rifles in 1994 in the U.S. Supreme Court, as everyone owns these things. And then, of course, Heller's in 2008 saying that we have a right to modern firearms, i.e. modern handguns. And in 2008, modern handguns were, of course, revolvers, but they also include semi-automatic pistols, which are really the same exact technology as a semi-automatic rifle, except semi-automatic rifles are bigger with longer barrels, obviously, than a handgun. But they're all the same semi-automatic firearms technology. You pull the trigger and the gun reloads so you can fire again until you're out of bullets. And they all take magazines that hold multiple rounds. So you're only dealing with modern technology in Heller itself. And again, when you're dealing with in common use by Americans for lawful purposes, you're already accounting for the society we now live in today, in the year of our Lord 2023. So any societal issues, concerns, any technological changes or issues associated with dramatic technological changes are already incorporated into what we as Americans have the right to choose, i.e. what we pick and select and use for our arms, i.e. those arms that are in common use. So all these things are already accounted for implicitly in the in common use test set forth in Heller, which is specifically excluded, according to the sentence itself, from the other cases that might implicate unprecedented societal concerns or dramatic technological changes. But it gets even more clear that it's absurd to think that anti-gun judges and anti-gun lawyers can use this language to justify banning modern firearms. Because in addition to the text, as I point out in my article in the Harvard Journal of Law and Public Policy, you can link to down below and read if you want, I point out that the Heller decision was decided in 2008. Do you recall what happened in 2007, unfortunately? Well, in 2007, you had a mass shooting of over 30 students, as I recall, on the campus of Virginia Tech by a shooter who was using modern semi-automatic firearms, handguns in that instance, with magazines that held, multiple rounds. They were quote-unquote large-capacity magazines and semi-automatic handguns. And over 30 people were killed in 2007. Yet in 2008, the Supreme Court decided the Heller decision. And you know what I also point out in my article, and I have the cites for it, you can confirm it, that lawyers literally submitted to the United States Supreme Court evidence of that Virginia Tech shooting and other evidence of mass shootings and other evidence that semi-automatic handguns and magazines that went along with it were part of the problem. And what did the Supreme Court do when confronted with all of that evidence of mass shootings and modern firearms? They gave us the Heller decision. So the Supreme Court is obviously familiar with mass shootings and modern firearms technology. So in light of that, this language we see in 2022 in the Bruen decision referring to unprecedented societal concerns or dramatic technological changes, obviously whatever they're referring to in that language in Bruen cannot possibly mean the technology that was used in the Virginia Tech shooting or the fact that you had mass shootings, because before 2007, i.e. before 2008's Heller decision, you had many mass shootings, including but not limited to the Virginia Tech in 2007, literally a year before Heller. And of course, we know just historically, mass shootings and mass killings are not unprecedented. Unfortunately, they're not unprecedented societal concerns. Keep in mind that the Supreme Court says in Bruen that there are societal concerns that go back to the 18th century. Well, we know in 1770, you had the Boston Massacre, where eight Americans were killed and shot and killed by British soldiers in a mass shooting in Boston. 1770, right before the Revolution. And then, of course, we all remember in 1764, we've talked about this in our history videos here on this channel. In 1764, you had the infamous murder of schoolmaster Enoch Brown and 10 students by merciless Indian savages, also known as the Indians. 1764, a mass killing of 10 students and the schoolmaster when the Indians came in and killed them all with clubs and scalped them all. So the idea that the founding fathers in the 18th century were not aware of mass killings is simply a lie, because they knew all about the Boston Massacre and Enoch Brown. And keep in mind that in 1776, when they wrote the Declaration of Independence, they did not call the Indians, which is, of course, the word that's correct at the time, and also was correct by Supreme Court lingo, because Supreme Court Justice Anthony Kennedy referred to them as the Indians in oral argument in Heller. We know they referred in the Declaration of Independence as the merciless Indian savages. And that was not a name that was lightly given out. Their behavior certainly warranted that description. We don't need to get into all that here, but that was in 1776. So do you think by the time we get to the year of our Lord, 1791, some of the memories of the merciless Indian savages and their behaviors, and of course the mercenaries brought on board into our country by King George III and the atrocities committed by those Hessians and mercenaries, do you think all those lessons of history and brutality were lost on our founding fathers in 1791 when they enacted the Second Amendment? Hardly. So the point being that when the Bruen refers to other cases other than Bruen and Heller, might implicate unprecedented societal concerns or dramatic technological changes that perhaps require a more nuanced approach to the analogs, this has nothing to do with arms ban cases, AR-15s or magazines. Because whatever this refers to, it's not referring to mass shootings and it's not referring to semi-automatic firearm technology, neither of which are unprecedented societal concerns or involve dramatic technological advances or technological changes. Whatever they're talking about, Captain Kirk's phaser down the road perhaps, it's not talking about what we're litigating today. So do not let the anti-gunners use this language, or do not let anti-gun judges get away with using this language to get around Second Amendment jurisprudence that's favorable to us. Don't let them get away with that sleight of hand. I flagged it for you. You now know it. You now know to step up and prevent it from happening. And last but not least, I just want to make one final point, that nothing about this language, if you're litigating other cases, allows the anti-government, allows the anti-gun or the anti-gun government officials or the anti-gun lawyers or the anti-gun judges to get around having to force the government to come forth with historical analog laws to justify their modern-day gun control laws. This is not an excuse or get-out-of-jail-free card for the government. It's just saying that you can loosen up the analogs if you're dealing with something that's like this. But again, as far as I'm concerned, none of these things exist today, but they may exist down the road, and that's all the Supreme Court was saying. But again, the unprecedented societal concerns and dramatic technological changes that are being referred to in Bruen do not exist right now, but they may exist down the road. We will see. All right, folks, hope you learned a little bit something here at the Four Boxes Diner channel. Don't forget to follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.